Welcome to this episode of the Legal Paige podcast. Today, I am sharing some spooky, scary stories as we are a few days out from Halloween. Now, these stories are going to be much scarier than you would hear around a campfire, watch on Netflix, with your hands covering your eyes. You know, all those murder mystery shows that I'm like terrified of, but can't help but watch and just dive into. I am going to pick up pretend like you're picking up a horror section at your favorite bookstore, but with scarier and spookier stories because they're all about business. And as business owners, it's literally our worst nightmare to hear about these kind of things and be like, oh my God, are they going to happen to me? So I'm sharing the situations that you want to avoid at all costs as a business owner. So grab your favorite blanket, a pen and paper to maybe take a few notes, maybe a bowl of popcorn, maybe some Halloween candy, and get ready to be scared and then be educated on how to avoid these spooky, scary business horror stories. You're listening to the Legal Paige podcast, where we chat about life and business with a legal twist. I'm Paige, attorney and photographer helping online businesses and creatives tackle their business dreams without breaking out in hives. No more legal mumbo jumbo. This podcast features simple, bite-sized advice that'll have you legally legit in no time. Are you ready? Let's get started. As a reminder, before we get into this episode, I am legally obligated to give my disclaimer. So I am an attorney, but I am not your attorney. All legal information I talk about on this episode is intended for the masses and a large variety of different businesses. I am only your attorney when you hire me and we sign an engagement letter for me to work specifically on your legal issues. Please feel free to seek out another attorney in your hometown if you need specific legal advice or contact me for more information. Alrighty, here's the episode, friends. Hey, you guys. Thanks again for listening. I talked about it in my intro, but we're getting into some spooky, scary business stories that I want you to avoid at all costs. Now, some of the information that I'm going to talk about today has been legally changed in order to protect all of the people involved in these stories and some, client confidentiality stuff. But there are just some that I really wanted to share. Some of them I've gathered from DMs. Some of them I've gathered from my Facebook group. Some of them have been actual one-on-one client issues. Honestly, there's thousands of business owners out there. I've even scoured business horror stories in other business groups on Facebook as well. I feel like everyone always has one big goal in common with their business, and that's to ensure that it's protected to the best of their abilities and to avoid these really, really bad horror stories at all costs, which is what I'm going to go over today. So I'm going to give you the facts of the case or the matter or the issue. And then I'm going to talk about how I would suggest you avoid that and my big takeaway. Okay, so the first scenario I have for you is pretty simple. A gal used 2 rescheduling paragraphs in her contracts. She had one for a certain purpose and one for another purpose. And then she had a force majeure clause. And then she had a COVID rescheduling clause. And none of them really explained why the other one would not be impacted or would not be the one that should be interpreted under that circumstance. So these paragraphs basically negated each other. And my biggest, the person actually put the 2 paragraphs up in this group, and they said unfortunately I had 2 sections of my contract that talked about rescheduling. They kind of say different things depending on kind of the circumstance. My client is claiming one. I think this falls under the other. And now we're in kind of this rescheduling debacle and battle. My biggest, that is everyone's, I think, honestly, spooky, scary, hide under the rug, like, I don't want this to ever happen to me situation, because the big takeaway here is to just slow down. I want you to read through your contract and really understand what your contract is stating. I want you to go through and make sure there's only one clause dealing with cancellations and one clause dealing with reschedulings and one clause dealing with, COVID-19 reschedulings. And then at the bottom of that clause, it needs to have a sentence that states like, this clause supersedes the entirety of this agreement for COVID-19 purposes only. Like, it has to be that clear in your contract if you're talking about rescheduling in two different sections. So that I feel like, and people were putting in the comments of this particular question online, I think the big issue here is you've got contradictory paragraphs, contradictory sections in your contract. And ultimately what happened here is the service provider kind of had to bow down and own up to their mistake in their contract. And the client ended up winning in this scenario. So you just don't want that to happen to yourself. So that's a very clear-cut, spooky story. Here is a story that is not so clear-cut. So the person says, this is my first time dealing with this. I've worked at an event last Saturday, and my contract states that the remaining balance is due day of. And this person never had an issue getting the payment from the client. And sometimes they even send it the next day. And this particular service provider is always okay with that. And sometimes this person said that there, is a tip involved. So sometimes it's worth it for them to just get it the next day. And the issue here is that the client then was really hard to communicate with. So the backstory is the service provider and the client went over the timeline for the event the day before. This client was pretty upset because there was travel time between locations, and that was included in the total coverage of the package. And, the client was like, no, the timing you're on site is actually how long you need to, provide services for. Driving time isn't included. And so this client beforehand, and again, before the person showed up, it was already kind of turning into there's some client confusion. They don't really understand your policy on this. They wanted this service provider to work an 11, 12-hour day for the price of 8. And the client was very rude, hung up on this particular service provider. And so that was kind of how this service provider was going into this wedding or event scenario with already kind of bad juju, essentially. And they weren't paid in advance. So I'm okay, there's 2 red flags here, right? But then the client essentially was super awkward during the event. And now the service provider has sent multiple emails and texts about the remaining balance. And this client is now deciding to pay through we'll put in here a third party payment processor that wasn't how they originally paid. So they're not just paying through Honeybook or Dubsado and the actual payment link that the service provider is paying through. They're sending a Zelle link or sending it via Venmo Business, but they didn't even send it to the right email address or the right person. But they're sending screenshots. So essentially, I feel they're trying to cover up the fact that no, we did send you the final payment, but they actually haven't sent the final payment. It wasn't even how it was supposed to be sent. So the horror story, there's a lot to unpack here. But I thought, the key issue is client communication. What does your contract state, and are you abiding by that contract? And then how best to proceed in this kind of horror story situation. Because you have a client who's really not working with you, is upset with you from the get-go because they were confused about the hours of coverage, was awkward during the day, and you went to the event without getting paid in full. That's my number one rule here. My biggest takeaway for people, especially in the wedding and event industry, I can tell you countless times, I would say the biggest issue we have with payments is people who provide services without getting paid the full amount prior to the event happening, we are constantly dealing with errors in payments afterward. Because then you're putting yourself in a position where, did they like the services? Do they like the photos? Do they like the video? They have like all these additional arguments they can make to not pay you. When you have done all of the work at that point, you've provided services day of, you've edited, you've delivered your, product to them probably online. So you're done. Like your end and your rights and obligations under the contract are complete. And that is where I suggest you don't wait to that point to then ask for payment. I suggest that you ask for payment at least 7 days in advance, if not 14. And most wedding and event service providers ask for it 30 days in advance. I also think that the best metaphor or like analogy for this is like a wedding cake. You would the actual bakery who's making your wedding cake would never say, "Oh yeah, you can come pick up your wedding cake and you can take it to the event and you can eat it and you can ask your family and friends and you can decide like if it's 150% satisfactory to you and then you can pay me for the wedding cake." That would never fly. Like to take the cake out of the bakery, you have to pay for it up front. And you probably already had like taste testing with them. Like you have decided, I mean, unless there's like some tragic negligence on behalf of the bakery and something went wrong with the cake, like obviously there's like refundability and like legal stuff at play there. But what I'm saying is like, why put yourself in a position as a service provider where there's going to be more legal hiccups down the road? And this client is already being kind of a witch, to use Halloween terms. And you like, if they're already being challenging and there's communication errors and if you have like a red flag or like a gut feeling that this may be a challenging client to work with or a challenging event to provide services at, you 100% should get paid before. Like I wouldn't even show up without getting paid before. And you need to have that in your contract to begin with. Like you are not obligated to show up unless all fees have paid prior to the date of the event. So that's a big takeaway here as well. Now, in terms of like the client kind of, beating around the bush with how they're sending these payments, I feel like there's some bigger issue at play there where like, why are you allowing these various options, whether that's like an ACH transfer, a Zelle transfer? They're paying via Venmo now. Why would you allow that to occur when they first paid like probably their non-refundable retainer via your online like CRM system? Honeybook in this case was what this person used. That should be in your contract as well, that they can only pay through your payment link and, the invoice that you send to them, and that they need to pay via credit card or debit card. If you have another form of how they're delivering payment, whether that's like a certified check or whether you do allow ACH transfers, like that should be the only way that they are sending money to you. So those are like my big takeaways. I mean, this is a really like sticky, bad situation. And I feel like another takeaway I would say for you is just to embolden and empower you as service providers with stick to your contracts, but also like be okay to like tell the client like what they are doing is not okay, that they are putting you in X position prior to the event date, that you will not be showing up until final payment is made, that there have been some communication errors or, just missteps, previous to the event occurring, kind of lay those out, write all this out in an email, make sure it's like actual documented proof that you can use if something were to occur and they didn't pay and then you didn't show up because you told them you weren't going to do it because that's what your contract stated. So that's a horror story for you. And I hope you never have to deal with that. But I feel like a lot of the business horror stories I'm going to talk about today have to just deal with like unruly clients. So this is one of those. Okay, in that same vein, there was a situation that popped up from a photographer as well that says, I am being sued-ish by a client They have canceled and they want all of their fees back. So this was prior to the event date happening. They had already provided some services. I'm assuming here this is like a wedding photographer and they've done like some type of engagement session. And they are like now threatening for like breach of contract. They hate their images. They're saying I breached because I didn't do X, Y, Z in, these photos. And they are also saying that they know a lawyer. So what do I do? There's a lot of things here. The biggest one is the threat of knowing a lawyer. I want you all to be aware that there's always going to be that like moment of, oh my God, they know a lawyer. They're going to sue me. These are threats. They're kind of blank threats. They don't really hold any value because they actually haven't sued you yet. So just be aware that you also have a lot of arguments on your side prior to a lawsuit happening, and they're just trying to like kind of, jam the knife into you a little bit in order for you to concede to their terms of how they want to cancel versus the terms that are actually in your freaking contract. So even if the client is unhappy with you, you need to really like take a step back. I always say if something like this occurs, like it usually gets heated pretty fast because of like the emotional toil it's going to take on you and your client. So instead of just like rash sending things emotionally back to them, whether that's in text or email, I want you to cool it for at least a couple of hours, digest what they're saying, and then think about the facts of the case. Don't put like emotions into your response. What are the facts? What kind of clauses in your contract are there to protect you in this situation? Probably an artistic discretion or artistic style clause that they have, taken the opportunity to look at your portfolio prior to signing your contract, and they agree that, your photos will be consistent with your style, but that it's probably ever evolving. Also, that if they decide to cancel within X period of time, are there kind of liquidated damages in place for all fees paid up to the point and all services that have been rendered up to the point, including your non-refundable retainer as well. So all of that should be in your contract as well to protect you. And then ultimately, like, I feel like there was an open-ended claim here of breach of contract without them expressly delineating what clause you breached and why, which is why I think it's like a non-threatening thing for them to say that they know a lawyer. They're just trying to say that and get a refund. Because if they had actually talked to the lawyer would have told them, like, you can't just say you breached the contract. You need to say how, why, what clause, and what your damages are, because there has to be like a duty, a breach, a cause, and damages in order for them to, like the elements of a negligence claim or breach of contract claim there. They would have to fulfill those elements. So again, I think this is an open-ended threat. Like it's actually doesn't mean anything. And that's my takeaway. Like how I would suggest you respond to that situation is non-emotional. Go back, state clauses in your contract, state what they're doing. It sounds like they're voluntarily canceling. And just because, we have this pop up all the time in the Facebook group. Like I've done XYZ for my client. They've decided to cancel and now they are going with a different photographer or a different videographer. That's fine. They have the right to do that, but that doesn't mean you breached or you did anything wrong. It just means maybe they have a different taste and style now for their wedding and event, and that should not be put on you. So you absolutely should not have to refund anything. There's no breach of contract on your end. And it sounds like this particular service provider as well, like felt like I didn't breach. I don't even know what they're talking about. So if that's the case, like don't be emotional, state, contractual language in response back and really try to resolve the issue with your client. And then if all fails, get a lawyer involved. All right, another horror story. My client signed the contract, but hasn't paid the retainer and now has ghosted me. Casper, where are you? I mean, seriously, I feel like the ghosting thing has been kind of more and more of an issue. I'm in this one group on Facebook for adventure elopement photographers, And there was a thread recently about ghosting and like just clients ghosting like crazy, which is interesting. I mean, there's a variety of factors that play there, whether like your marketing and advertising and communication is on point, whether that is your ideal client, whether the clients are just price shopping as well. That could definitely be a thing that they're doing, ghosting you. But I think it's imperative here to realize that a contract has been signed. And this particular service provider like didn't know what to do. Like the contract has been signed, they haven't been paid, but do they need to like show up on the date? Do they need to send like a cancellation letter? There was like so much going on. And they had heard from like another person that the contract had been signed. I think under this scenario as well, a retainer had been paid in some way, shape, or form. So just like the remaining amount hadn't been paid. I'm not totally sure, honestly. But this particular person said like the wedding or event had already occurred. And they heard that they used like a different provider, but now they can't get a hold of this client. They're ghosting them. Like they can't get any information if it already occurred. Do they need to show up on the date? And this service provider was kind of freaking out. Like, what do I do? So they and the client had signed the contract. I think a small portion had been paid for retainer of services, and then they had done some work, but at the end of the day, they like ghosted basically halfway through. They can't get a hold of them. They have no idea what's going on. And this horror story got worse because I think they asked for help like the week before the event. Like the event was coming up that Saturday. And so there's multiple things and takeaways here. I mean, first of all, there's nothing you can do about a client ghosting. You can send a certified letter in advance. This is why I suggest you do get addresses from clients prior to them signing the contract. They put in like their email address, yes, but also their personal address. So you can send a certified letter to them that you are indeed canceling because they've breached, they haven't communicated with you, they haven't paid their final balance, so you will not be showing up. You can do it that way. I would also suggest you email them, you text them, you call, like you send every type of documentation possible to explain the scenario that you're not going to show up because they haven't paid and they've ghosted you, and you have been informed by XYZ sources that the event has already occurred. And so, all of these, I mean, there's probably 5 clauses there that they've breached, right? They didn't notify you properly. They didn't cancel properly. They're using, you're not the exclusive service provider anymore. They haven't paid the fees in the fee section. So you can state all of these things. I know some people also recommend that you just show up on the day and you take pictures and you document that you did actually show up and that you were ready to perform services, but the event wasn't there, didn't happen, and you get like documentation that you were there to provide services when you were supposed to. This is when like a client doesn't sign a cancellation agreement and you're just not really sure what to do. So under that type of scenario, yeah, I would, if you're really worried that it may still be happening and you don't like actually have proof that it already occurred and maybe there is another photographer that's going to be there, I don't know, then just show up, document things and be like, I'm upholding my end of the contract. Like I don't want to breach my contract here and you still owe me fees paid. So that's why I'm here. And then document all of that. Either they're there or they're not there. If they're there, it's probably going to be awkward and you're going to have to figure out what you want to do. Probably take some pictures, get like a signed, affidavit, on a piece of paper from the venue owner that you did indeed show up, but your services weren't, the client requested your services not being needed. And then you're probably going to have a battle thereafter to get the final payment and cancel and all that stuff. So I think the former is probably the best case scenario where you just tell them multiple ways, hopefully a certified letter, that they've breached, that you aren't going to show up, that if they owe any fees up to the date of that, cancellation, like what those fees are. And then, kind of good luck collecting those fees essentially is what I'm going to tell you. And rather than showing up. So anyway, that's a horror story for you as well. Okay, so this next scenario is also involving photography. And this particular photographer was like mentoring another photographer in their kind of vicinity or locale and had kind of given some good business tips. Well, about a month later, this other photographer started up their own business and literally used all these other photos from this other photographer for advertising purposes. So like without permission, like copyright infringement up the wazoo here of commercially using someone else's copyrighted photos to advertise your own business on Instagram, on their website, like on everything. And this particular photographer was like, this person is so kind. They're just so new. I just don't think they understand. Maybe they got this idea that I was giving them all this, business advice and that it was okay then to use my stuff as they get started, but I never said that. And it's obviously there's now going to be like confusion if, some of my clients are going to go to her now and all of these different things. So this is a scenario of like you're trying to do good by mentoring, but then it doesn't go well for you and someone steals your stuff. So basic copyright infringement issues, I would always just try to resolve the issue yourself. Contact this other person, kind of let them know, they probably meant no harm, but this isn't okay. This is copyright infringement. It's going to create client confusion between clients thinking it's your business or her business, that you didn't authorize use of these photos and that you need them to be taken down immediately. And then just kind of see what they say. Like, don't give any more like threatening legal language to them. Give it some time. And if they don't take it down in like 7 days or 30 days, then they kind of know what they're doing at this point, and it's intentional infringement here. And then I would send a cease and desist. So you can either send a cease and desist yourself for copyright infringement, or you can have an attorney send one for you. I honestly think a good takeaway here is just communication regarding your mentoring. If you are just kind of doing it out of the kindness of your heart, just be really clear. Like, this is what I would suggest. Like, please don't, copy anything from my website. Please don't, just because I'm like showing you my pricing guide, don't literally copy my pricing guide. All of that is copyright infringement. So just kind of alerting people to that beforehand, especially when they're new, is nice. And then, maybe consider actually having like a mentorship or a VIP day or, one-on-one coaching program where they do have to sign a contract with you, even if it's for like not a lot of money and you're doing it out of the kindness of your heart, just like laying out all of those procedures beforehand as well, so you can have a contract to fall back on for this situation. Are you starting to wonder if your contract actually protects you from unforeseeable and unpredictable situations, such as the COVID outbreak, natural disasters, inclement weather, or third-party claims? I want you to protect yourself and your business by ensuring that you have all of the necessary protection clauses in your contracts to avoid these type of scary, spooky what-if situations. I have a checklist and it's free and it's just for you. It's going to tell you all of these protection clauses that are needed. It describes what they mean to you and your business and how it's going to protect you. You can download this free checklist at thelegalpage.com/protection clause checklist. Again, that's thelegalpage.com/protection clause checklist. All lowercase, no spacing, all together. thelegalpage.com/protection clause checklist to get your free download and ensuring that you are protecting yourself from all of the things. Okay, this is an issue with a one-on-one client that popped up a while back. So he had, and again, I'm changing like lots of things here, but for client confidentiality purposes. But so this guy was a wedding planner or designer. He put together like this huge styled shoot and also worked with like a publication for this styled shoot and like a ton of other different vendors. They all get to this styled shoot, like no contracts are signed. It's all just kind of like, in writing or in an email that they're going to do XYZ and they've agreed to XYZ. This planner, this guy hired an intern recently, and the intern was like helping with a bunch of stuff for his business. So the intern was there at the styled shoot. The shoot went off without a hitch. Everything went well. The vendors were happy. A lot of these vendors, this particular guy had really good relationships with, business relationships, personal relationships. A lot was said at the styled shoot because it's kind of just, wedding industry vendors like in their element, in their zone, and they don't have clients around. So they open up a lot to each other. They tell a lot to each other. They talk a lot about their business. They talk a lot about clients and issues. They talk a lot about their pricing structure. So all of these kind of things were just like out in the open during this styled shoot. 2 months later or 3 months later, this intern leaves the company that this guy had hired her for. And the intern starts their own wedding design company. And the intern basically steals everything and made relationships at this styled shoot as well, because the intern had learned networking is key, and basically started putting all these other vendors on their preferred vendor list, used photos, was able to contact the photographer and use photos from this styled shoot. Also, this styled shoot hadn't been published yet. So the intern leaked all these photos when they started their own business. And then there was this huge issue surrounding the actual publication person backed out. They didn't want to publish it anymore, which upset every vendor. So this guy had this issue with an intern, obviously copyright infringement and stealing business ideas, basically stealing preferred vendors, stealing pricing lists, stealing all of these confidential things that were said at the styled shoot and using them towards their own new commercial benefit. But now they are having this derailment of issues surrounding the publication backing out and all of these vendors' time and energy not being worthwhile. And some of these vendors got very upset and wanted him to pay them a bunch of money back for their services, because the entire purpose behind it was frustrated and no longer happening. So that's a lot to unpack, but also it's just a really unfortunate situation. The one thing I tell my clients to begin with when I'm working with them is you can only control yourself. So there's a lot of things here that happen that are outside of your control. You had the best of intentions working with this intern or associate or whomever it was, but they ultimately kind of backstabbed you, and they did very selfish things to benefit their own, being and their own business endeavors. And that is not on you. There's a few things, obviously, they didn't have a contract in place. So I think having a contract in place with your intern surrounding confidentiality, surrounding anything they come in contact with your business would be a breach of confidentiality and a breach of contract issue, so you could sue them right away for it. Also, a styled shoot contract with all of the vendors regarding, this is a big one we put in our styled shoot contracts, is confidentiality, just because everyone's so open to disclosing things at styled shoots that word can get around that you said something to someone and it can just really impact your business badly. So having that type of contract in place is really important. And then also no guarantees of publication, explaining that you have the intention, you are working with this publisher, but at the end of the day, that is the publisher's decision whether or not, if something goes wrong at the styled shoot, not above and beyond what this issue was, what actually happened. Say the publisher didn't end up liking what happened with, the table display or the archway display. There's florals that were used in it that they don't want to publish anymore. It doesn't go with their theme. I feel like there's a lot of things that could occur, what if scenarios with a publisher backing out. And so I always just say this is your intention to do this, but all vendors understand and agree that publishing is not guaranteed. And also that there will be no reimbursement from the lead person of the styled shoot, and that each individual vendor is contributing their own services, their own time, their own wholesale pricing and payments for things that they're providing. And like they are ultimately like going to hold harmless the person who put it together if anything were to happen and not occur to their, understanding, I guess. So those are some big takeaways here. And I think, one of my takeaways is always like, take it as a learning lesson that you have to be really careful with who you hire. In this particular instance, I think this guy should have hired this person as an employee, and it was like a contractor, so they were able to back out really easily. So they weren't able to sign a non-compete. There wasn't any particular policies and procedures in place for how this intern was going to be working with them. They just kind of like sent their hourly rates or hourly timesheet every month and got paid accordingly. When you actually hire an employee, it can really help you avoid competition issues. So you can't have a contractor sign a non-compete, but you can have an employee sign a non-compete. And all of these issues here probably could have been avoided by an easy breach of that non-compete if the person would have been hired as an employee. So while there are costs involved with hiring on employees and there is additional like loopholes you have to jump through, obviously putting them on payroll, having them sign employee agreements, setting them up on UI, workers' compensation, ensuring that they're under your insurance policy as well. All of that is like you can control them and you can control the competition that could potentially occur thereafter working for you. And so a non-compete would have been very helpful in this situation, but there was just no way that it was set up for a non-compete type of scenario. So something to consider as well with like a horror story like that, where you're like, oh my God, I have the best of intentions going into a styled shoot. Just think of things like if you're any type of wedding vendor going into a styled shoot, there's a lot that can occur there. Like maybe be really careful who you're saying what to. Be really careful of the people that you're bringing to these styled shoots. Be really careful about the relationships and networking you're doing with everyone at the styled shoot, because I think a little bit too much is divulged at styled shoots that probably shouldn't be. And that can also obviously just come to bite you in the butt later on. So be careful of that. Sorry about that horror story scenario, because I know a lot of you are probably like planning styled shoots or want to like build your portfolios, but just be careful and have contracts in place to protect you. Okay, this particular situation kind of involves family law a little bit, but I think it pertains to a lot of different scenarios where you're photographing a minor. So two people were going through a divorce, and their daughter, who is a minor, had been a model in different sessions with a photographer. And this photographer had posted this model on its business page. The mom had signed off on a model release. Like they thought everything was good. But now, because the mom and dad are in a divorce, the father, who didn't sign off on anything, is like threatening to take them to court over their daughter kind of being posted everywhere. And the photographer's really at a loss of what to do. They have a model contract in place with the mom, but were they supposed to get both parents' permissions? And my business is getting drug into it. They're starting to send me lawyer things from his attorney. So this is a not fun situation. I think it's good for everyone to know, for senior portrait sessions, like high school seniors, for any type of like kids that are in family photography as well that you're doing, you need to be aware that divorces can happen and it can get very, very sticky very quickly because people are obviously possessive over their children. And it's a really unfortunate thing that is like spiteful in divorce disputes, is they use their kids as kind of pawns. I mean, it's horrible, but it is a reality for divorce attorneys to deal with. And in this scenario, that's what's happening here. And so it kind of puts the mom in a bad position because the mom signed the contract and honestly released liability from the photographer for this respect. But now the photographer's like, I just want out. I don't want anything to do with this. So if at all possible, take photos down, be done, delete photos anywhere. If that's like something you can do, is the easiest way to kind of avoid a bigger dispute here. I would also work directly with the father's attorney and not go through the father, because I think there was there's a lot of nuanced things that I didn't explain here, but I think there was some threats coming and there's just like a lot of emotions at play. So when those kind of things happen, it's best to just go to the attorney who is really speaking on behalf of their client and figure out what this client wants, what's going on with the photographs, and what their argument is surrounding what the photographer's liability and risk is, because they actually have a model release from at least one of the legal guardians. I don't think you need to have both parents sign off on contracts all the time. I think it's cumbersome. Oftentimes, there's one particular spouse who is contracting with you for family sessions and things along those lines. So it's just hard to have both parties sign. But a takeaway here could be the photographer is always going to have both parents sign the contract just to avoid this issue from ever happening in the future. If that is something that would help you sleep better and give peace at night, then I think you should do that. But I think also one legal guardian's permission is 100% fine. Just remember that model releases can be revoked. So like model contracts or model releases in clauses or in model release clauses in contracts, if anything happens wonky with people's privacy later down the line, they can always request a revocation of a model release clause. And this is where I'm just like, honestly, it's not worth it to fight it. Like if they want privacy, take these photos down, move on, don't get involved in this. It's not worth it. And same with people like in boudoir photography as well. This is a big one where you like probably have a pretty hefty model release clause. We do TLP contracts for boudoir photography specific do, and it allows your client to kind of choose what they are comfortable with. But there could be something that happens where maybe they break up. I've had this happen as a photographer. I did boudoir photos for a client. The couple broke up. The person had their kind of explicit photos and they just wanted to be like done with that whole scenario of like why they shot those photos, who they shot them for, and like who they gifted it to. And they revoked their model release from me, and then I had to take everything down. And that is okay. You have to respect people's privacy, and that's really important to do. So yeah, just to protect yourself the best way possible, I just make sure you're contacting the attorney if there is an attorney representing someone that's threatening you. And then also just realize like contracts can be signed, model releases can be signed, but model releases in particular deal with personal privacy. And it's going to be an uphill battle for you to win that, even though they did sign it in advance. So you were okay to have that up on your site. You are okay to have that on your Instagram account. Like you did not breach anything by putting it up there. But you may have to now take it down because they want more privacy, and there's like a whole other legal dispute happening here with the divorce. So that's not a fun situation to deal with. Definitely like a horror film and getting threats and that kind of thing. They're just like dragging your business into it for no reason. But I think that you can definitely handle this pretty easily and efficiently as a photographer. Okay, and then the last horror story I have for you is regarding a online coach, a business coach. They had a contract that their client signed. The client went about halfway through the program and then essentially dropped out, stopped paying for everything, and they only paid their first payment, and I think there was 3 or 4 additional payments thereafter. So they did receive at least half of the coaching program educational opportunities that were involved in it. They did learn things. They did go on Zoom calls. It was like an online coaching program, group coaching program. And they did benefit from it in some sense. So the client, of course, ghosts this particular online coach, doesn't ever pay anything, obviously has a signed contract in place, already paid the retainer. And this online coach was out probably, I think, $2,500 or $3,000. Like it was a lot of money. And so they wanted to fight it based off of principle. They didn't want to allow this to occur with any other group coaching clients. They wanted them to pay. They felt like they had delivered services. They had done some like one-on-one services as well that were a part of the group coaching. They had already performed their end of the contract essentially. And then this online coaching client like backs out. Also, it's online coaching. So they don't really have a way to contact them other than their email. Ghosting is occurring. They're having a hard time contacting them whatsoever. They're not really sure what to do in terms of garnering payment or if it's even worth it. So this is one of those you have to decide and choose your battles. Is it worth it? And based off of principle and the large sum of money that was due under the contract still, yes, this person wanted to fight it. Okay, how do you fight it? Do you have, again, their address on file? Can you send a certified letter? Is there a way to send some type of demand letter on behalf of them? You're probably at the point now where if your client's ghosting you, you probably can't settle this yourself. So you need to contact an attorney, and the attorney is going to start sending, certified letters. They're going to be sending emails. They're going to be sending all kinds of demand requests on behalf of their online coaching client to this client of theirs that isn't paying, and going through like all of the things that they breached in their contract and how, they need to pay. All of these services have been performed. And so ultimately, this actually took I think it was a long time, like 8 to 12 months to resolve. They ended up having to hire, like the lawyer had to hire someone that could investigate and figure out where this person was, because then they started using like pseudonyms online and they couldn't figure out who this, like they shut down all their social media accounts. They had no idea where this person was living anymore. They found like multiple bogus addresses. I mean, it was a nightmare. But ultimately, hiring a lawyer did end up working, and they were able to find the person and sue the person. And they had default judgment against them because the person didn't even show up in court. So, the end of this horror story is just because you win in small claims court, and this person did because they like sued and then the person didn't show up and they had documentation and proof that they did indeed get served for this particular lawsuit. Collecting judgment is challenging. So collecting the actual payment, like, oh, you won $2,500 or whatever amount it was. It was a lot more than that, you guys. Like this person, it was a really, really hefty group coaching program, like tens of thousands of dollars. So it was worth it for this person to take this client to court, because you're probably thinking, oh my God, Paige, like why would someone take someone to court and pay that much of attorney's fees for that period of time? Also, this attorney was on a contingency fee. So contingent on them winning, they would get a certain amount. I think it was a friend, and there was a little bit of like pro bono work happening here. So the lawyer was doing it not for like an hourly rate. So the client wasn't having to pay a ton of money for all of the work, but collecting judgment ended up being a nightmare as well. And I don't know how the end of the story occurred. I don't know if judgment like actually got paid. They had to go to collections, and sometimes it just sits in collections. And if the person doesn't pay or if they're in debt, like you're just part of, being the debtor creditor issue with, all kinds of bankruptcy issues. So, but you have a collection judgment against them, which is something, and it means you've won. So at the end of the day, I mean, this is a nightmare. And there, I guess it's hard to say. I don't really have any like specific suggestions for you other than this person ended up coming to me thereafter and being like, we need to revise my contract. I want to have way more clear policies in place. I want you to look through my entire workflow process of booking and onboarding clients. I want to make sure that this doesn't occur in the future, or I can try to avoid it at all costs. And so that's where I came into play. So like this whole scenario happened with somebody else, some other attorney. But I want you to have as strong as contract as possible, especially with online coaching. But just realize my takeaway here is you're going to have lemon clients. You're going to have really sour clients that are just going to take you through the ringer. And I want you to be ready for that. Like, try to put your emotions aside. Try to realize like it's kind of just the price of doing business sometimes. And you need to decide like, do I want to do the court route and the lawyer route, or should I just like leave this be, take it as a loss and move on? And that is determinative on your personality, your emotional state. You need to decide what's worth it to you. This particular client was fine with fighting it. They wanted to do it, and it didn't give them a bunch of emotional distress. But I would say for other clients of mine, it would give them so much emotional distress that they like would not be able to handle it and sleep at night. And it would just like impact every aspect of their personal day-to-day things that they would do. So yeah, I mean, you can try to avoid all these things in contracts. There's certain things you can do, but I mean, you can't help it if you're just going to have a really crappy client that's going to breach everything and then do all of these additional things so that you can't contact them, and then don't give a shit that you're taking them to small claims court because they are already filing bankruptcy, and then you have a judgment against them, but there's still really nothing you can do. So there's just bad people out there that are going to do this, and just be aware that they are out there and it's really sucky. But just be prepared for that and be like, you know what? I have so many other awesome clients that this one client is not going to get me down. And I'm just going to like move on from this and learn from it and try to, maybe do a better like initial client questionnaire or, booking process, discovery calls to really weed out people that I don't think are the right fit. All right. Well, I could go on and on and on with horror stories, bad, spooky things that happen as business owners, but I don't want to scare you guys too much. I've got stories upon stories upon stories because honestly, once you hire a lawyer, it's because you had a yucky situation turn into a legal situation, and that is a horror story in and of itself. So all of my clients' one-on-one issues are horror stories. And I think anyone asking legal questions in groups is dealing with a horror story of their own. I hope you aren't too spooked from all of these, but I just wanted to share these in order to educate you and empower you so that you can A, legally protect your business, and B, know what to do on the off chance that any of these kind of things ever happen to you, and how you can either avoid it completely or be prepared to tackle it yourself or with an attorney's help. And I wanted to invite you, if you have any spooky, scary stories of your own that you would be willing to share with me, you can kind of change facts, you can change genders, you can change names around, and I would love to hear them and kind of see, if you needed advice or suggestions on that, you can ask it in the TLP community on Facebook. If you need actual legal help with that spooky, scary situation, I can definitely do that as well through my law firm, Griffith Law. Or I would just love to hear your scary story and kind of let me know how it all went down so that I could maybe share it or use it in another fashion here at TLP to educate and help others avoid that situation that you went through. Alrighty, TLPers, see you over in the next episode, and happy Halloween. Thanks so much for listening to this episode of the Legal Paige podcast. See, I told you being legally legit isn't so scary. Be sure to visit thelegalpage.com for all show notes. And it would be super awesome if you could head over to iTunes and leave a review. Last but not least, don't forget to join my free Facebook group for unlimited legal and biz Q&A. Chat soon, Legal Pagers.